We are on the record on 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick appears in person and with counsel Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck. We are ready to continue the jury trial. And Mr. Jones or Ms. Keck, are the people ready to proceed?
We are.
And Ms. Schnock, is the defendant ready to proceed?
Yes.
Are there any issues we need to bring up prior to the jury coming in?
I don't have anything, Your Honor.
Ms. Schnock?
I have one minor thing that I would like to bring up with the court before we bring in the jury.
You may.
Mr. Jones and Ms. Keck were kind enough to give us the exhibits that they intend to use at trial. Part of the exhibits that I believe are coming in today are with respect to certain court orders that were entered through the parties' divorce. I have no objection to the orders coming in, but I do have a problem with these orders being shown to the jury with certain points being highlighted like this. And it's only drawing attention to certain points of the order. Like I said, if they want to point things out in the order and ask the witness questions about that, but I do have a problem with the jury being highlighted and blown up certain portions of these orders.
All right, Mr. Jones, you wish to be heard?
Judge, the orders will be shown to the jury as part of a demonstrative exhibit. We are certainly allowed to make part of that order larger so it's easier to read. Otherwise, we're going to sit here and try to read it, and the jury may not be able to see it in the order. So absolutely, we are absolutely allowed to blow up parts of those orders. If Ms. Schnock wants to blow up different parts of the order, she has the opportunity to do that. But this is our case, and if there are portions that we think are relevant, we should be and are allowed to highlight them, not just by talking about them, but by showing them to the jury.
Ms. Schnock, you wish to be heard further?
The jury's perfectly capable of reading on their own, Your Honor.
The court believes that if the people first publish the full order that they have entered, then after they have published the entirety of the order, then they are allowed to highlight certain parts either by blowing it up or highlighting it in some other manner. So as long as the people publish the full document first, then they are allowed to make reference to and highlight certain parts of that order. And then
Along those lines, Your Honor, would be submissions from Rick Zimmerman's guardian ad litem report. The people have provided me an exhibit which gives me 1 page of his second supplemental report, and I would request that that report come in its entirety. And if the people want to, as you said, make note or highlight, if you will, that 1 page, they certainly can. But in my opinion, it should come in its entirety as opposed to on a page-by-page or piecemeal basis.
Mr. Jones, you wish to be heard on that?
Judge, the entire report will be part of the exhibit. The entire report is part of this exhibit. We don't have to show every page of this divorce file. We can show portions of it that are relevant to our case. Ms. Schnock is free to show anything else she wants, but it's our case, Your Honor. We're allowed to show what parts we think are most relevant and to present them to the jury in a way that makes sense to them. We don't have to show them every page of this divorce file. And that's what Ms. Schnock is asking, that she get to decide how we present our case to the jury. And that's not fair, Your Honor. We're allowed to present the case in the manner we think is appropriate and makes the most sense to the jury.
Ms. Schnock, you wish to be heard?
I'm not asking that the entire file be published to the jury. I'm just asking that the report that the people are going to be relied on be admitted in its entirety. And I think Mr. Jones just said that it would be admitted in its entirety, which is fine. I'm not expecting him to show everybody everything, and that's not even the entire divorce file. But I'm not expecting that he do that. I was simply making a record and making sure that we had a mutual understanding that the entire report would come in, and if they want to highlight certain things, they can. If I want to highlight certain things, I can. But I think it's important that the report come in for completeness, and so that the jury has a basis for the recommendation that the people would be highlighting.
Yes, because of the rule of completeness, the whole report, it will be admitted originally, all right? And then after that report is admitted, then either of the parties can pick and choose what parts of that report they get to highlight or they want to draw the jury's attention to. So as long as the full report is admitted originally, then that will be used. Then people or the defendant can use any parts of that report. Anything further that we need to discuss?
Not for me, Your Honor, thank you.
No, Your
Jones. All right, and what the court's going to try and remember to do before we bring the jury in, once it's 9 o'clock and everybody who wants to be in the trial is here, I will remind and try and admonish the gallery again about cell phones, okay? So unless there's anything else, we will be in recess until 9 o'clock. Hey, good morning. We are on the record with 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick appears in person and with counsel, Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck, and we are ready to start today's trial. We are still on the people's case in chief, and for the spectators in the audience, I want to remind you, you are allowed to have cell phones in the courthouse. However, those cell phones must be turned all the way off and must be out of sight while you are in the courtroom. So if you have your cell phone in the courtroom, you must, at this point, turn them off. That excludes media, because media is allowed to have their devices, are allowed to be able to communicate during the trial, but they need to have their badges on, because if you have your device out and you do not have your badge on, then you can expect to be approached by security, because if you have your device out or your device goes off, then security will escort you out and you will not be able to come back in until the next day. So I'm just reminding you all of that, and I believe security will try and remind you throughout the day or at breaks as to that policy with the cell phones. And then after having said that, Mr. Jones, anything before we bring the jury in?
Nothing from the people.
And Ms. Schnock?
Nothing from us, Your Honor.
All right, let's bring in the jury.
All right. The session is now reconvened. Robert K. Adrian, judge presiding. You may be seated.
Good morning, ladies and gentlemen of the jury. We are ready to continue our trial. We are still on the prosecution's case in chief, and Mr. Jones, do you have evidence today?
I do, Your Honor. People would call Denny Woodworth. Your Honor, while Mr. Woodworth is coming in, we would ask the court to take judicial notice of Exhibit 72, which is the court filings in the Bliefnick versus Bliefnick divorce case 21D16.
Any objection to the court taking judicial notice of its records in that file?
No, Your Honor.
We'd ask that those.
Court will take judicial notice of those records, and that whole file will be admitted into evidence. And then, wait, are you good there? Okay. Wait, are the jurors okay with being able to see with the court reporter there? Okay, everybody okay? All right, then you do not have to move. All right, Mr. Woodworth, if you'd raise your right hand.
You do solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. And if you could come around here and have a seat there. Then scoot up to the table to where you're comfortable, bend that microphone in front of you and speak towards the microphone, please.
Can you tell me your name?
Dennis Woodworth.
Mr. Woodworth, what do you do for a living?
I'm an attorney with the law firm of Blickhand, Timberwick, and Woodworth.
What kind of law do you practice?
We practice general practice, divorce work, personal injury, DUI, anything that comes in the door with the exception of Social Security disability claims.
How long have you done that?
28 years.
Mr. Woodworth, in 2021, did you begin to represent someone by the name of Rebecca or Becky Bliefnick?
I did.
And what was the nature of that representation? What were you representing her in?
She was served with divorce papers and she was a respondent in a divorce.
When was that divorce filed?
It was filed in January of 2021.
When you began representing Ms. Bliefnick, did you file a temporary order, or was a temporary order entered in that case dealing with temporary custody, child support, maintenance, et cetera, issues like that?
Yes, it was.
Your Honor, that's part of People's Exhibit 72, I believe. It's been admitted into evidence, and we would ask at this point to publish the temporary order filed August 3rd, 2021.
Mr. Jones, I'm going to stop you. Okay. So the court's records in 21D16.
21D16, Your Honor.
Yes, okay. And that's exhibit number for the record.
So the entire file is Exhibit 72.
Okay, exhibit 72, and that's been admitted. And then you are making reference to a portion of that, correct?
Correct. Specifically, it's a temporary order entered by the court in that file on August 3rd, 2021.
Okay. And is there any type of, are you using any type of letter, like, so that we can have exhibit 72A?
We did not do that. We can modify that.
Let's
going forward.
modify that so it makes easy reference to that. So,
Then, Your Honor, we'll call the temporary order on August 3rd, 2021, Exhibit 72A.
okay, exhibit 72A is a temporary order. All right, and that's been admitted as part of the original file. You may proceed.
If we could have that up on the screen. We have highlighted some portions of that temporary order 72A. And under A on that temporary order from August 3rd, 2021, that order indicates that Ray Bliefnick shall not have any unsupervised contact with the minor children. Is that correct?
That's correct.
Do you know who Ray Bliefnick is?
That would be Tim Bliefnick's father.
And as long as you were involved in the case, this temporary order remained in effect that the defendant's father would have no unsupervised contact with the minor children.
That is correct.
Under paragraph B of that temporary order, the petitioner, and the petitioner in this case is the defendant, is that right?
That is correct.
And I guess for the record, do you see the petitioner here in court today?
Yes.
Could you point him out, describe what he's wearing?
Mr. Bliefnick is wearing a brown shirt and sitting at council table on the far east end.
Your Honor, we'd ask that the record reflect he's identified the defendant as that petitioner.
The record will reflect that the witness has identified the defendant.
And under paragraph B, the petitioner, the defendant, was to pay maintenance in the amount of $2,150, $100.50. Is that correct?
That is correct.
And as long as you were the attorney in the case, that had not changed.
It did change subsequent thereto. There was a motion to reconsider that changed. What, the maintenance didn't change, it was the child support amount that changed.
Maintenance amount stayed the same.
Maintenance amount stayed the same, correct?
And in the temporary order of this date, the child support that the petitioner was paying to Becky Bliefnick, the defendant was paying to Becky Bliefnick, was $472. Is that right?
Correct.
And if you could blink the screen, Ms. Cat. In the course of your representation of Ms. Bliefnick in that divorce, was there discussion about a firearm, specifically a CZ-75 9mm handgun?
There was.
In the course of that divorce, did you make any requests of the defendant and his counsel?
Yes.
And what was that request?
We had filed a petition for the return of that gun to Miss Bliefnick.
Was that petition granted? Did the court order the defendant to return that gun to Ms. Bliefnick?
The court did.
And was that a order in the court that was also in 21D16?
It was.
Your Honor, we'd ask that that order of injunction from October 22nd, 2021, which is also part of Exhibit 72, be introduced. And again, we have not done this yet, but moving forward, we will. This would be Exhibit 72B.
All right, thank you.
And permission from the court to publish
You
it.
may publish it.
Is this that order of injunction that we referred to that is dated October 22nd, 2021 and signed by a judge?
Yes, it is.
And Ms. Keck, could you? I'm sorry, and there were a couple other things I wanted to cover on this. In that order of injunction, were both parties also ordered that they would not go to the other party's residence except for the exchange of the minor children, that neither party shall enter the home of the other party, nor shall either party have the children go into the home of the other party without specific permission of the party's home that would be entered?
That's correct. At
that time, was Rebecca Bliefnick living at 2528 Kentucky?
The marital home, yes.
And she had been given, awarded at that point, the marital home, not in a final sense, but at that point, she was awarded the marital home. Is that right?
She was granted exclusive possession of the home
At 2528 Kentucky.
Correct.
And the defendant was living in a different location, 1641 Hampshire, is that right?
That's correct.
And according to this order, Ms. Bliefnick could not go into the defendant's home at 1641 Hampshire, and the defendant could not go into her home at 2528 Kentucky.
That's correct. That's correct.
Under paragraph 12 of that temporary order, Exhibit 72B, the petitioner shall turn over to the respondent the 9mm handgun, CZ-75B, as soon as she purchases a safe for the same and provides to the petitioner a receipt of said purchase. That in the event the petitioner cannot locate the 9mm handgun, CZ-75B, then he shall turn over a 9mm Ruger 9CLS handgun to the respondent during the pendency of this cause of action. Is that correct?
That is correct.
Ms. Keck, if you could blank the screen. During the course of your representation of Ms. Bliefnick, was that firearm or any firearm ever provided to her?
No.
During the course of your representation of Becky Bliefnick, did she ever provide documentation to you that she had purchased a gun safe?
She went out and immediately purchased a gun safe.
Did you speak with Ms. Bliefnick about why she wanted that gun?
I did.
What did she say about why she wanted that firearm?
She wanted it for protection.
Protection from who?
Her husband, Tim Bliefnick.
The defendant?
Yes.
Mr. Woodworth, in the 28 years that you've practiced law, how many divorce cases have you handled?
50 to 100 divorces a year.
Fair to say 2,000 to 3,000 divorces in your career then?
Yes.
In Adams County,
All surrounding
Brown
counties.
County,
Brown County,
Calhoun?
not Calhoun.
Okay. In those nearly 3,000 divorces that you've handled, have you had clients say they were scared of the other side of the divorce?
Objection, Your Honor. Anything any of his other clients would have told
That-
him would be inherently
That will be
hearsay.
sustained.
The defense has said that this is just divorce talk.
I haven't said anything
It'll
yet.
be sustained, Mr. Jones. Ask a different question.
In those 2,000 to 3,000 divorces that you've handled, have you ever had a client murdered before?
No.
That's all the questions I have.
Cross, Ms. Schnott.
Thank you. Good morning, Mr. Woodworth.
Good morning.
I want to start by talking about the order that was entered on August 3rd, 2021.
Okay.
Was this an agreed upon order, or was this an order by the court?
Was this the order that was on the screen previously?
Yes, it would be People's Exhibit 72A.
I may have that with me if I can look at that, unless you want to put it back up on.
If you want, if
Probably
Mr.
should
Jones wants to.
Put it back up on the screen if we could.
I would need to see the entire order, the introductory,
The entire order's in the file. We don't have to-
and the date is August.
The date of that order is August 3rd, 2020.
Okay. I've got a copy of that with me. Okay, that was a hearing that we had.
Okay, so that would have been a court order and not an agreed upon order,
Correct,
correct?
yep.
Okay, and as part of that order by the court, was an order for temporary maintenance, correct?
Correct.
Okay,
Yep.
and the duration of maintenance in the state of Illinois is dictated by statute, correct?
Correct.
And the duration of maintenance is largely in part dictated by the length of the marriage, correct?
Correct.
And there are certain tables, if you will, that dictate multipliers, if you will, that dictate how long maintenance should be paid depending on the length of the marriage, correct?
Correct. Correct.
Maintenance can be made retroactive, correct?
Correct.
So if there were to be a permanent order of maintenance ordered in any case, that person would get credit for any temporary payments made under the temporary order, correct?
Absolutely.
Okay, and so Tim would have gotten credit for all of the maintenance payments going back to August 1st of 2021, correct?
Anything that he paid, yes.
Okay, and he would not be required to pay maintenance above and beyond what the statutory guidelines say, correct?
Unless the court ordered otherwise, correct.
And so, Your Honor, may I approach?
You may.
I am handing up what I have marked as Defense Exhibit 1. And you're familiar, and you said that you were familiar with the multiplier tables with respect to maintenance and your involvement in practicing law, correct?
Correct.
And I'm handing out Defense Exhibit 1 for identification, Mr. Woodworth, and if you could take your time looking at these tables and let me know when you've had sufficient time to look at this.
Yes, this is a multiplier table.
Okay, and these are accurate and in line with the law today, correct?
Yes,
Okay, so a marriage of 10 years has a multiplier of 0.44, correct?
correct,
And a marriage of 11 years has a multiplier of 0.48, correct?
correct.
And the parties in this matter were married in September of 2009, correct?
I do not have a copy of the petition for dissolution of marriage was filed, so I don't know the actual date of the marriage. If you got a copy of that, I can,
It's
People will stipulate that the marriage occurred in 2009.
Okay.
okay,
And then the time period would have been told when the divorce was filed in January of 2021, correct?
and when you mean told, what do you,
The duration of the marriage would be determined from the date of the marriage until the time of filing.
the time of divorce?
Time of divorce.
Time the divorce is
Okay.
granted is
And-
duration.
And so that would determine the length of the marriage, which would determine the length of time that maintenance should have to be paid, correct?
Correct,
Okay.
Yep.
And like you said, that number can vary if the court thinks it's appropriate, correct?
correct.
Courts don't always deviate from the statutory guidelines, do they?
They don't always know.
And not only can the court deviate from the guidelines with respect to the duration of maintenance, but they can also deviate from the guidelines with respect to the amount of maintenance, correct?
Correct,
And in any divorce, maintenance is not a guarantee to anybody, correct?
correct,
There are certain statutory factors that need to be considered by a court and by the attorneys and by the parties in order to determine if a person is even an appropriate candidate for maintenance, correct?
that is correct.
And one of the first things that you need to look at is whether or not there is a demonstrated need for maintenance, correct?
That is correct.
So if somebody does not have a need for maintenance, it is unlikely that a court could order maintenance, correct?
That is a very good possibility.
And on the other hand, if somebody does not have the ability to pay maintenance, a court could possibly say you do not have to pay maintenance, correct?
Or could deviate from the
Yeah,
the
could
amount.
deviate
Yeah.
down depending on the circumstances,
That is
correct?
correct.
Okay. During your, and the same thing with child support can be made retroactive as well, correct?
Correct,
And in this matter, Tim would have gotten credit for all child support payments that would have been made effective August 12th of 2021, correct?
correct, yeah.
So whether the divorce went on for a year after that, or 2 years after that, or however long after that, though there would still be credit given where credit was due, correct?
Correct.
Okay. When did your involvement in the divorce terminate?
I believe it was in around November of 2021.
Okay. And is that when you handed this case off to your partner, Mr. Timmerwolke?
Yes, correct.
All right, during your involvement from April 2021 to November of 2021, did you ever file a petition alleging that Mr. Bliefnick had not paid maintenance?
Without looking at the file, that was 2 years ago. I'd have to look at the file to see if I had filed a petition for contempt or something to that effect.
Take your time.
That would have been petition that I would have filed if that,
Absolutely, and when somebody doesn't follow a court order in divorce court, then the remedy is to file a petition to show cause, correct?
that's correct.
And that is to bring to the court's attention somebody's failure to follow a court order, correct?
That's correct.
And in that event, the court could order sanctions and enter an arrearage on the unpaid balance, correct?
Good, yes.
All right. Would looking through your file sufficiently refresh your recollection as to whether or not you did that?
It would if I had the entire file.
Surely if Becky came to you with complaints that maintenance wasn't being paid, you would have filed such petition, correct?
Oh, absolutely.
Okay. And if Becky came to you with complaints that Tim was not paying child support, certainly you would have filed a petition to show cause, correct?
I would have.
And if Tim had not been making the mortgage payments as he was ordered, then certainly you would have filed a petition to show cause with respect to that, correct?
I would have. The only way I wouldn't have is if, and a lot of times in our practice, what we do is we send the other attorney a letter first saying, hey, your client isn't doing this. Please address this before we have to file contempt. So that would have been the only other way that situation would have been brought to the attention.
And as you're sitting here today,
Ms.
do you have,
Knock, I'm going to just stop you.
okay?
The court has the docket sheet from the file Exhibit 72, which has been admitted. Mr. Woodworth, if I hand you that docket sheet, would you be able to look through that to see if, in fact, there was a petition filed?
I can certainly look at it.
All
It's
right.
several
Any
pages long, I
objection
know.
to allowing the witness to look through the docket sheet of that file?
No, Your Honor.
Ms. Schnock?
No.
And Mr. Woodworth, while you're looking through that file, I have the file pulled up, so if you see something that could be a question, then I can show that to you on the computer.
There was a motion for indirect civil contempt of court filed on July 21st of 2021, but the docket sheet doesn't say what that particular issue was that was raised in that contempt petition.
All right. Mr. Woodworth, I have that actually pulled up on the computer. Mr. Jones and Ms. Schnock, if you want to come and look at that.
Judge, that one, that would not be relevant for.
I'm looking at a different one than I think she's picked up. Ms. Schnock, you can scroll down. Counsel.
Okay, I don't think that has any.
Scroll. Go ahead and scroll when you are ready.
There's nothing in here though. Actually don't.
Wait, go to the microphone. All right. The record should reflect that the court has pulled up a document which is entitled Petition to Find Petitioner in Indirect Civil Contempt of Court. That was filed on July 21st, 2021. It is a 4-count, it's a 5-count petition, it's actually a 6-count petition. Both the prosecution and defense has had a chance to review that. Based on that, Ms. Schnock, you may proceed.
Thank you. Was there ever a judgment, in your involvement in the case, was there ever a judgment entered on any arrearage with respect to maintenance or child support?
Not that I recall.
Okay. Also, as part of, I believe that temporary, let me pull that up real quick. During your involvement with the parties' divorce, were they ordered to communicate through the Our Family Wizard app?
Yes,
And is that an app that's commonly used in divorce proceedings to keep people honest with their communications?
it is, to keep a record of what is said between the parties.
Yeah. So if somebody says something in poor form, there's a record of it, correct?
There is,
And that's to protect both parties, correct?
Correct.
Okay, and that was done in this matter, correct?
correct.
Okay. Mr. Woodworth, moving on to the order that was entered on October 22nd of 2001. This would be the order of injunction. I believe it's People's Exhibit Number 72B.
And was that dated October 22nd, 2021?
Yes, sir.
Okay.
And paragraph 12 is the provision of that order that deals with the return of the 9mm CZ, correct?
Correct.
And the third line of paragraph 12 contemplates an event where the petitioner in that matter, being Tim Bliefnick, cannot locate the 9mm handgun. So when that order was entered, is it correct that it was contemplated, that it was a possibility that that could not be located?
There was. Mr. Bliefnick's attorney had made the statement that he may not be able to find that handgun.
Okay, and that was back in, going back to at least October 22nd of 2021, correct?
That is correct.
And did Becky provide you a receipt of the purchase of that, of the gun safe?
Yes.
Okay, and do you recall when she provided you the receipt of that gun safe?
It was very quickly after the order was entered.
Okay, and did you turn that over to Mr. Bliefnick's attorney at the time?
Yes.
Okay. You stated to Mr. Jones that Becky told you that she wanted that gun for protection, correct?
That is correct.
Okay. During the course of your involvement in Becky's representation, did you ever file a petition to show cause to return the handgun?
In looking at the docket sheet, I don't believe I did unless the contempt petition had to deal with that. And I think that was I think that petition predated the order
Okay,
entered.
okay. And had Becky came to you and said, will you do something about getting this gun back to me? Certainly you would have done that, correct?
Oh, I'm sure it would have, yes.
Okay. The same thing with any other protective orders. If a client comes to you and says, I'm scared, I need you to do something for me, you would do that, correct?
Yes, if it's within the law, yes.
Sure. And also along the divorce lines, there was discovery that you were involved in from April through November of 2021, correct?
massive amounts of discovery in this case.
And during the course of discovery, did Becky ever show you any pictures of any bruising or marks on her purporting to be made by Tim?
She had complained of some of his, I guess, episodes, she would call them. But as far as showing me the actual picture, no.
Okay, and there was nothing that you filed on her behalf as far as any restrictions or anything like that?
I did not, because these parties, early on in the case, a petition for exclusive possession of the marital home was filed and granted. So Ms. Bliefnick stayed in the marital home. Mr. Bliefnick went and got a residence of his own. So they were separated from the beginning of this divorce proceeding, or
Okay.
pretty much from the beginning.
Okay, and at the time you got involved in the divorce, had they already separated physically?
They had separated physically.
Okay, and was it during your involvement in the divorce that exclusive possession was granted?
Correct.
Okay, and once exclusive possession, oh, strike that. Do you recall when that was done? It would have been done through that temporary order,
The
correct?
temporary order that was referred to earlier, I think, was July, I believe.
Okay. Do you remember when, during the course of your representation, Becky would have made that statement to you with respect to the gun?
Well, it would have been when we filed the motion, there was a motion filed concerning that gun.
Okay,
So it would have been shortly before that motion was filed.
okay. And if Becky would have came to you with requests that could have been filed within the law, you would have done that for her?
Correct. Yeah.
No other questions, Judge?
Before you get started, Mr. Woodworth, I want you to explain one thing. You talked about the multiplier when it comes to maintenance, or which used to be called alimony, and I don't believe lay people understand what that multiplier is or how is it used. Could you just explain that for them, please?
Yes. For example, if it's a 10-year marriage and the multiplier is 0.44, you take 10 years times that 0.44, and that determines the length of the maintenance. So in that case, it'd be 4 years and 4 months. So.
Thank you. Go ahead, Mr. Jones.
Thank you, Your Honor. Just a few questions on recross and redirect, and I'll start with what the judges referred to, the alimony calculations. The maintenance or alimony calculations are not set in stone. It's not like you can go to put it in a computer program and find out exactly what it's going to be. Is that fair to say?
You can put it in the program, but ultimately the court is the decision maker when it comes to setting the amount of the maintenance.
And the court would hear evidence in a hearing like that to determine what the alimony would be.
Yeah, typically what happens is the attorneys on both sides prepare maintenance or child support calculations. Those are presented as exhibits to the court. The court can do its own calculations, however, if there's objections to one of the calculations or both of the calculations. So it can be input from both parties' attorneys and or the court's calculation.
And can the court hear evidence on that from witnesses?
Certainly can.
The petitioner could present evidence,
Correct?
the respondent could present evidence,
Correct?
but not if the respondent's dead.
Correct.
The respondent can't present evidence if she's dead.
Correct.
And that amount of alimony can deviate up or down depending on what evidence the court may or may not be able to hear, correct?
Oh, absolutely. Depending on the income of the parties, it can go up or down.
Are there other issues that might affect whether or not that alimony amount is deviated up or down?
The statute has several different factors the court can look at when deciding whether to deviate up or down. As Ms. Knox said, the need of a party is one of the biggest factors, and the other party's ability to pay. So when you have a situation where a person is making substantial income, and when I say that, over $250,000 per year, and you have another party that may be making $30,000 per year, the amount may be a certain dollar figure, but the court can deviate up based upon the ability to pay. And the other substantial factor the court considers is the lifestyle the children would have enjoyed during the course of the marriage. So the court's got to take all those statutory factors into account.
You told us one of those statutory factors is the respective incomes of the parties, is that right?
Correct.
When you were involved in this case, were you aware of the respective incomes of the defendant and Becky Bliefnick?
Yes.
With regard to their relative incomes, was one of them making substantially more than the other?
Yes.
And who was making substantially more than the other?
Mr. Bliefnick was.
The defendant?
Yes.
Ms. Schnock asked you whether or not you had ever filed any petitions in this case. Remember that question?
Yes.
And the court showed you a petition from July 21st, 2021. Is
Okay.
that right? Would it refresh your recollection if you were able to see that petition from the court?
Sure. Yeah.
Your Honor, I'd ask that the court allow Mr. Woodward to look at that petition from July 21st, 2021.
All right. Mr. Woodworth, if you could stand up, please, because I can't move the screen. And if you... Going to make this bigger for you, Mr. Woodworth. The record should reflect that the court had pulled up the petition on its computer screen. The court has allowed the witness to review that petition. And Mr. Woodworth, is there any further parts of that petition you'd like to view before we proceed?
No.
All right. You may proceed, Mr. Jones.
Mr. Woodworth, you had in fact filed a petition to show cause against the defendant in this case, is that right?
Correct.
And one of the allegations in that petition was failure to pay the alimony as ordered by the court, is that correct?
Correct.
That's all the questions I have.
Ms. Schnock, I'm going to give you a chance to recross if you want.
Thank you. The court you never pressed the issue with the court with respect to that petition to show cause, correct?
That could be correct. I don't have the entire file anymore because it got subpoenaed.
We'll stipulate
case.
that there was no hearing on that.
There was no, the people will stipulate that there was no hearing on that request of the court, okay?
Okay.
And when Mr. Jones was asking you about the income of the parties and setting maintenance. You said that the parties can fight over that, correct?
Absolutely.
And they can present their own evidence with respect to what they think their income is and what they think their spouse's income is, correct?
Correct.
And part of that would include a provision of the law regarding imputing income to a party, correct?
It could.
Okay, so if a party has the ability to make more money than what they are actually making, a judge could use a different number in calculating maintenance and child support if they believe that party has the ability to make more than they're reporting, correct?
Yeah, if a judge believes that somebody is, I'm going to call it underemployed, that could potentially happen.
Sure, and if there's a record of somebody making, let's say, $10,000 a month for several months, and all of a sudden it goes down to $5,000 a month, that could be grounds for an attorney to say, we want to impute income to this person because they have the ability to make $10,000 a month, as they have shown us over the course of however much time.
It could happen, yeah.
Okay. So just because an attorney prepares a calculation and puts certain numbers into a computer program does not mean that a judge has to accept it. Is that fair?
That's correct.
And sometimes as divorce attorneys, do we use numbers to our client's own advantage within the bounds of the law?
Yes,
Okay, so if it may not be uncommon to reduce somebody's income within the bounds of the law for purposes of making these calculations.
true.
I think a common practice would be not including bonuses as part of income, correct?
That could happen. Somebody
Okay.
can use a calculation not including bonuses, and the other side could use a calculation including that bonus.
Okay, and so when we as attorneys provide these proposed calculations to the court, sometimes it's a wish. Is that fair?
Could be,
We
yeah.
don't necessarily expect to get that sometimes. Is that fair?
That's correct.
And we do the best that we can to advocate for our clients within the bounds of the law. Is that fair?
Correct.
Okay, and that doesn't mean that you have to accept the other side's numbers or the other side's position, correct?
And the court doesn't either.
Yeah, and that's just part of being and working in divorce court. Is that fair?
Correct.
No other questions?
Mr. Jones?
Mr. Woodworth,
Yes.
there was never a final divorce hearing in this case, was there?
There was not.
And that's because Becky Bliefnick was murdered.
Correct.
That's all the questions I have.
All right, you may step down. If you could, hand yes, those other exhibits. Thank you. Ms. Schnuck, if you could grab your exhibit. Mr. Jones, you may call your next witness.
Your Honor, the people would call Sarah Murphy.
Ma'am, if you could step up to the front of the courtroom. Right. Come on up a little closer. Raise your right hand. Be sworn by the clerk.
You do solemnly swear that the testimony may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, if you'll come around here and have a seat right here in this chair. Kind of scoot up to the table to where you're comfortable, and then you can bend that microphone so it's in front of you, and please speak towards the microphone, okay? All right, you may inquire.
Thank you, Your Honor. Can you tell us your name, please?
Sarah Murphy.
Ms. Murphy, how are you employed?
I work at Blessing Hospital.
What do you do at Blessing Hospital?
I'm a nurse on the vascular access team.
I'm going to ask you to
Okay, sorry.
Talking as fast as I talk, really fast. When you say vascular access team, tell us just generally what is that?
So our team, we place peripheral IVs, midlines, and PICC lines in the patient population, IVs and fancy IVs.
Something I can't do. When you say your team, how many people are a part of your team?
We have 4 RN positions.
So it's 4 separate nurses.
Yes.
And do you have a specific spot in the hospital where you work at when you're not with a patient?
We cover the whole house, so we go from unit to unit, but we do have an office in the radiology department.
In that office, do all 4 of the nurses that work with your team work in that office?
Yes.
When we say an office, is it multiple cubicles? Is it multiple rooms? What is it?
Currently we have 2 rooms, but our desks are all in one room. Our other room is a procedure room.
So pretty close quarters, fair to say.
Very close quarters.
Was one of the nurses that worked in the vascular access team, call it VAT team, right?
VAT,
The
yes.
VAT team with you, Becky Bliefnick.
Yes.
When did Becky Bliefnick start working with you in that team?
May of last year.
So May of 2022?
2022, yes.
How often would you work with Becky?
In the beginning, very frequently, and then this last year, she and I worked every Friday and every other weekend together.
Since you were working with Becky in these close quarters, would you talk a lot?
All the time.
Because one of the things you talked about regularly was her divorce.
Yes.
And would you talk about her feelings and thoughts about that divorce?
Yes.
Were you aware of who the person was that she was trying to divorce from?
Yes.
Who was that?
Tim.
Is that how you knew him from her, Tim?
Yes.
During the course of these conversations, did you have discussions about the defendant's father?
Yes.
How did she refer to him
Ray.
as Ray? What did she tell you was her thoughts about the defendant's father, about Ray, what she wanted to happen?
That she did not want the boys to be alone with Ray.
When you say the boys, her sons,
Her sons, yes.
did you also talk at one time about something potentially happening to her?
Yes.
And fair to say, were you kind of, you yourself, when you started this conversation, kind of joking around?
Yes.
Tell us how it started.
Usually my husband and I would have had a little argument, and I would tell her how angry, not angry, but, mad I was. So we would be joking around like, oh, I should just get rid of him, or something to that. I thought we were joking. I was joking. And she would always say if something ever happened to her, that we should make sure we look at Tim.
Looking back, do you wish that you would have taken that a little more seriously?
Yes.
Did you also have recent conversations in 2023 before she was murdered about her upcoming divorce hearing?
Yes.
Do you need a minute?
Nope, I'm good.
Okay. Did she tell you that she was ready for that divorce hearing?
She was very excited.
What did she tell you specifically about that upcoming hearing?
That
Objection. Anything that Rebecca said would be hearsay with respect to what was coming on at the hearing. We've had,
Okay. That will be sustained. There are certain, and the court would note, there is objection made pre-trial as to hearsay statements that the witness can, this witness and other witnesses can testify to. The court takes this as a renewal of those, of that objection. The court overrules those objections, but the court does not believe that the statements that she is about to make, which are hearsay, were part of that hearing. So the court is going to sustain that part of the objection.
Thank you, Your Honor. When you were talking with Becky in 2023, did she also tell you about a statement that Tim had made to her about the upcoming hearing or about their divorce proceedings?
We talked about it a lot.
Was there a statement that he made about playing games?
Yeah.
Can you tell us what that was?
One of the last conversations I remember having with Becky, she was reading me a message, and the only thing that stuck with me is Becky said, "I'm tired." He said she was tired of.
Counsel,
Can we approach that?
we can, ma'am, if you'll stay there. We're going to All right, the objection was sustained in part and overruled in part, and Ms. Keck, you may proceed.
Thank you, Your Honor. Ms. Murphy, we were talking about, one of the last conversations that you had with Becky. Can you tell us, was that in January or February of 2023?
It was during basketball season, so I believe January.
And during that conversation, Becky told you something that she said Tim had told her, correct? And in fact, did she?
Is that yes?
Oh, I'm sorry.
Yes, sorry.
And did she tell you that defendant Tim had told her he was, quote, according to Becky, tired of playing your stupid little games?
Yes.
No other questions, Your Honor.
Ms. Schnock?
Thank you. Good morning, Ms. Murphy. I have some questions that I'm going to ask of you. If you don't hear me, which I don't think will be a problem, or if you don't understand me, will you just let me know? Thank you.
Yes.
Okay, your association with Becky is through work, correct?
Yes.
Okay, were you friends outside of work with Becky?
Not as in we hung out all the time. We talked frequently.
Okay, so you talked frequently but didn't necessarily hang out socially, is that fair?
Yes.
Okay, and you and Becky and all of the other individuals with the VAT team, your desks are in somewhat close quarters, correct?
Yes.
And when you have, 3, 4, 5 women working in close quarters, there's chatter,
Correct.
girl talk. I think you referenced it when Miss Keck was questioning you, that sometimes you would come to work and you and your husband would have had a fight and you'd vent.
Yes.
Fair? And Becky would come to work and vent to you about the divorce, correct?
Yes.
And when you were having these conversations, it was in a joking manner. Is that fair?
Yes.
Yes, okay. And so when you were having these conversations, there were never any red flags that went up in your mind with Becky, correct?
No.
Because in your mind, these were joking,
Yes.
things that were said in jest. Is that fair?
Yes.
Okay. You do not know Tim, is that fair?
Yes.
Have you ever met Tim?
No.
You do not know him from anybody else in this courtroom as far as that is concerned, correct?
Correct.
Okay. Did you ever you never called the police on Becky's behalf, correct?
No.
Okay, and you never called Quinata or any other domestic violence assistance on Becky's behalf, correct?
No.
Okay. And there was, at least as far as you're concerned, there was nothing that she told you that caused you any concerns in your mind for her safety?
Physically, no.
Okay. No other questions, Judge?
Ms. Keck?
Thank you, Your Honor. Ms. Murphy, when you were talking, you were joking, correct?
Correct.
You don't know what Becky's thoughts were.
You don't.
That will be overruled. She can answer that.
You don't know what Becky's thoughts were.
I don't.
No other questions, Your Honor.
Ms. Stock, I'll give you another opportunity.
When these conversations were had, they were not serious, correct?
On my behalf, I was joking.
Okay, that's fair. And you wouldn't joke about something like domestic violence if it was a serious situation. Is that also fair?
Correct. I would not.
No other questions?
Ms. Keck?
No, Your Honor, thank you.
All right, you may step down. And is she excused from her subpoena?
Yes, Your Honor.
She can be released from ours as well, Your Honor.
All right, you're free to go or stay, however you wish, all right?
We should probably, we should probably take a break.
Judge, can we approach very briefly?
You may. All right, ladies and gentlemen, because the next witness may take a while, this would be a good time to take our morning break. So we are going to take our morning recess. You will be given 20 minutes, so you're able to refresh yourself, and we will be back in the courtroom at approximately 20 after.
All rise.
The jury has left the courtroom. Mr. Jones, Mr. Timmerwolke's next. Do you have another witness after that for this morning?
I do, and actually, I'm going to speak with Ms. Schnock and Ms. Keck, and we may call Rick Zimmerman first, because I think he'll be shorter, and then Jerry may take up the rest of the morning. But we have another witness on board too, if Jerry takes shorter. So.
Okay. All right, then we will be in recess till 20 after.
All right.
We are back on the record on 23 CF 170, People versus Timothy Bliefnick. Mr. Bliefnick is present in court along with his attorney, Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck. And we are ready to continue with evidence. Mr. Jones, are the people ready? Or Ms. Keck? Ms. Keck, are the people ready?
Yeah, Your Honor.
And Ms. Schnock, is the defense
Your Honor.
ready?
Yes.
All right, then let's bring in the jury.
All rise. Session of court now reconvened. You may be seated.
We are ready to continue with the people's case in chief. And Ms. Keck, do you have a witness?
We do, Your Honor. The people would call Gerald Timmerwolke.
Mr. Timberwolke, if you'll step to the front of the courtroom, raise your right hand and be sworn.
You do solemnly swear that the testimony may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come over here and have a seat, Mr. Timberwolke. And as you know, scoot up to the table and put the microphone in front of you and speak towards the microphone.
Very good.
You may inquire.
Can you tell us your name, please?
Jerry Timmerwolke.
Mr. Timothy, Mr. Jones asked, can you spell your first and last name for us?
It's actually Gerald, Gerald, Timmerwilke.
Thank you. Mr. Timothy, how are you employed?
I'm an attorney,
How long have you been an attorney?
46 years.
And what types of law do you practice?
General practice, family law, criminal law, civil suits, personal injury cases, workers' comp.
Is one of the people that you work with in your firm Denny Woodworth?
Yes,
In late 2021, did you take over a divorce case from Mr. Woodworth?
yes, I took over in November of 2021.
Was that a divorce case involving Tim and Becky Bliefnick?
Yes,
And do you see Tim Bliefnick here in the courtroom today?
I do.
Can you tell us where he's sitting and what he's wearing?
He's at the last chair at the console table, and he has, it looks like a brown top on.
Your Honor, the record to reflect that Mr. Timberwolke has identified the defendant.
The record will reflect that the witness has identified the defendant.
Mr. Timberwolke, when you took over that divorce, I assume you reviewed all of the filings.
Yes,
Did you continue then to represent Becky until February 2023?
yes.
During that time that you represented Becky in that divorce, was that an easy divorce, or how would you characterize it?
Very contested.
Were they fighting over everything?
Yes, they were fighting over mostly the children, the three boys. They were fighting over an issue concerning the defendant's father and his supervised or unsupervised visits with the grandchildren, property division, debt division, and maintenance and child support.
I want to talk to you about a little bit about those. You said they were fighting over the children. What were they fighting about with regards to the children?
When the case started out, my history of the case was that Becky was the primary parent for a number of years. She didn't work. When they had the children, it was by agreement. Mr. Bliefnick made good money, and she was a stay-at-home mother. That kind of changed. She became interested in nursing around 2016, and she started working as a part-time nurse. So by the time the divorce came, she was still the primary parent. When the divorce started out, it would have been, I'll use this, the old way, where maybe he was going to get weekends and have a weeknight. But as times progressed, the situation was that it became a 50-50. And that was through, actually, Judge Adrian had the case at that time.
While that divorce was proceeding, was there an order entered on August 30th, 2022 with regards to how the children would be exchanged?
I believe that they were to be exchanged at the house, but there was not to be entry into the house.
Was there also a provision about that they had to stay within 3 feet of their vehicle when they?
Yes, yes,
So not only could Becky not go into Tim's house, Tim couldn't go into Becky's house, they were supposed to stay within 3 feet of their vehicle at that time.
yes, that's what the judge ordered.
And that court order was still in effect when Becky was killed on February 23rd, 2023.
That's correct.
During the divorce, in December of 2022, you were getting closer to a final hearing, is that correct?
Yes,
As divorces get close to a final hearing, is one of the things that you do is each party files what's called a pretrial affidavit.
that's correct. It's under local rule, and it has a number of items that you need to put in it: general information, property division, debt division, matters concerning the children, and it's all laid out with exhibits. It's the primary, I guess, document that the courts look at to determine the case.
When you are putting those proposals together, does each side put in that pretrial affidavit their proposals about what they want the court to do?
Correct.
Did you file a pretrial affidavit on Becky's behalf?
I did.
Was that filed on December 16th, 2022?
Yes.
When you filed that, one of the things that was contested during the divorce was a handgun that was a CZ-75, is that right?
That is correct.
That handgun had actually been ordered to be returned to Becky before you even entered in 2020, correct?
That's correct. It was either done in July or August. I can't remember which order off the top of my head.
When you took over in November 2021, Becky still didn't have that handgun back.
She did not.
Did she have that handgun back when you filed the pretrial affidavit?
She did not.
In fact, did you, when you filed the pretrial affidavit, did Becky ask you, did you put in there that she still wanted that to be returned to her?
She did, and if it would not be returned, she was seeking the fair market value of it, which I believe was close to $800.
You said that there was also disagreements about finances. Was that something that Becky looked into herself as well?
Yes, she looked into it in great detail. She went back a number of years. The final figure that I came up with approached $481,000, and what she was going to put out to the court is discrepancies on money that her husband had either taken or things that he had understated, and she felt that she should be entitled to.
Objection, Your Honor, to what?
That will be sustained as to what she felt.
When you put the pretrial affidavit together, did you put in specific numbers about what you were seeking as far as additional assets that the defendant disagreed with?
Yes,
And did that total almost $500,000?
I believe it was.
Objection, Your Honor, what's the foundation? I don't know that the people, can we approach?
You may. The objection is overruled. You may proceed.
Thank you. Do you need me to restate my question?
I think that you were asking me how much money was involved, and I believe it was $481,000 in discrepancies, and she was, her pretrial affidavit, she was seeking that half of that be awarded to her in some fashion.
In that pretrial affidavit, did you also lay out what Ms. Bliefnick was proposing as far as parenting time?
Yes.
What was her proposal for how much both her and the defendant should get the children?
50-50.
So they would each get the children half the time.
Correct.
In December 28th, 2022, did the defendant's attorney on his behalf file a pretrial affidavit as well?
Yes.
In that pretrial affidavit, what was the proposal for how much parenting time that the defendant thought he should get?
I believe he was at 60-40 is what his proposal was.
And in the child support and maintenance calculations that Becky put together for her pretrial affidavit, the child support was $462, is that right?
That's correct.
And the maintenance was $1,346.
That's correct.
As divorces go, often attorneys exchange letters with proposals as well, is that right?
That's correct.
Mr. Timberwolke, I'm handing you what's been marked as People's Exhibit 73. Can you review that and tell us what that is?
This is a letter I received from Tim Bliefnick's attorney, Ms. Casey Schnock, that was a proposal to settle the case.
Your Honor, I'd ask that People's Exhibit 73 be admitted and published, please.
Any objection, Ms. Schnock?
No.
It will be admitted and you may publish it. That's why you have it, right there.
Thank you, Mr. Jones. Mr. Timberwolke, this is the letter, as you said, it's dated January 3rd, 2023, correct?
That's correct.
There are a number of things that are in this letter, but I want to specifically talk about the first bullet point that's in the letter on the first page to the far, the left as we're looking at it.
I can see it here. Yes.
Mr. Timberwolke, I'm talking about this right here, here at the top. And that, Mr. Bliefnick's attorney says that parenting time would be allocated on a 60-40 basis. So 5 overnights in a 14-day period for Becky and 9 overnights for himself. And it goes on to talk about how that would work. Now, up until that time, they've been exercising 50-50, correct?
That's correct.
So the entire time the divorce had been pending since it was 50-50, and then he wants to go to 60-40 where he gets the children more.
That's correct.
And as you said, Becky's proposal in December in her pretrial affidavit was 50-50.
Correct.
He then also talks about how on the top of the second page as it's scanned in here, the second bullet right here, that if your client, Becky, has a psychiatric evaluation and any recommended treatment, he may be willing to consider a 50-50 split if there are no more, quote, incidents of abuse. Is that right?
That was his proposal, yes.
He also, in the letter, says that he will not have to pay any child support. Is that right?
That was his request, yes.
And finally, with regards to maintenance, he says that her client will pay $750 per month. Is that right?
That is his request, yes.
And I'm sorry, I forgot one other thing. He also says here in the bottom middle part, that her client, the defendant, would receive the marital residence and Becky would have 60 days to get out and find suitable housing.
True.
And this is when they say the marital residence, they're referring to the residence at 2528 Kentucky Road, where Becky had been living with her children since the divorce began, actually before the divorce began. Is that right?
That is correct.
Or also in the letter, on the third part here, this top bullet says that client's father, Ray Bliefnick, would be allowed to have unsupervised visits with the children. Now, earlier you told us how that was one of the things that was contested. What was Becky's position about the defendant's father having any unsupervised contact with the children?
That was non-negotiable with her. She was ready to put on evidence, 5 witnesses that would support the position that Ray Bliefnick should not be around the children unless supervised.
Was this something that she was ever going to agree to?
She would have fought that all the way through the trial court and above.
When you received this letter from the defendant's attorney, did you share it with her as your client, with Becky Bliefnick?
I did.
What was her response?
Objection.
Objection is hearsay?
Yes.
Okay, and that's not one of the ones that we discussed. The response that will be sustained. You may rephrase your question, however, Ms. Keck.
Did you speak with Ms. Bliefnick about the letter?
I did.
After you spoke with her, what did you do?
I contacted Ms. Schnock verbally and told her the answer was no.
Thank you. After you told the defendant's attorney that the answer was no to her proposal, was this case ready for trial?
I believe it was, yes. I was fully prepared.
Now, fair to say, the divorces often get set for trial a couple of different times and then get continued, right?
It happens, yes.
But you get to a point where pretrial affidavits are filed, you're subpoenaing witnesses, and you're ready to go.
True.
On February 15th, 2023, was there an order entered in the divorce case?
I believe there was.
And did that set the case for trial?
Yes. That was the order setting it for trial, 5 days, a day, and then a full day, and then half days due to the judge that was assigned to the case had a difficult schedule and her other obligations, so we did it in half days mostly.
And Mr. Tremolke, I'm going to show you that divorce order from February 15th, 2023, which is part of People's Exhibit 72. And this was the order that we're discussing that was entered on February 15th, 2023, correct?
Yes,
And that order specifically set the first day of trial on March 2nd, 2023 at 1 o'clock p.m.
correct.
It also noted in that order that all issues would be decided during those 5 days.
Correct.
And that bottom part says that respondent will not be expected to present evidence anytime before March 3rd, 2023. Is that because you had witnesses that needed to testify?
Yes, some of those witnesses were away. They did not live in Quincy, so it was a matter that the court accommodated by giving us a start time with our witnesses.
Did you in fact have multiple witnesses subpoenaed after this order was entered that were going to testify March 3rd of 2023?
Yes, I had 5 witnesses.
Did you also expect that during this divorce proceeding that Becky Bliefnick would testify?
Absolutely.
And specifically, did you expect her to testify about finances?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about the defendant's father?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about parenting time and how much time she would get to spend with her 3 boys?
Yes.
Did she ever get to do that?
No.
Did you expect her to testify about maintenance?
Yes.
Did she ever get to do that?
No.
After this order was entered, was there a additional GAL report that was entered?
Yes.
And did that report recommend that there be continued 50-50 parenting time?
Correct.
When you receive things like a GAL report, do you then send that on to your client?
Yes.
And is that what attorneys do? They send GAL reports and other things like that onto their clients immediately?
Sure, yes.
Mr. Termolke, did you, at the request of our office, put together with a 60-40 split based on what the defendant had proposed, what the calculations would be for child support maintenance?
I did.
Show you what's been marked as People's Exhibit 74.
Before you start, Ms. Keck, the exhibit, the scheduling order that you showed, the court is labeling that as 72C so that we can make record and identify to that, and then you may proceed.
Thank you. Your Honor, Mr. Termolke, could you please tell us what People's Exhibit 74 is?
You asked me to calculate if Mr. Bliefnick would receive 60% of the parenting time and Becky would receive 40%. The child support guidelines in the law in Illinois, that's one of the 5 factors that go into how you calculate support. So that would have required no,
And so that's what People's Exhibit 74 is?
yes.
Your Honor, I ask that Exhibit 74 be admitted and published, please.
Any objection, Ms. Schnock?
No, Your Honor.
It will be admitted and you may publish it.
So, Mr. Termolke, this is as you said, there's a formula that's used by the state of Illinois, correct?
That's correct.
And this is a form that puts that formula basically together, fair to say?
Yes,
Now, this form, obviously, courts can deviate from this.
true.
So they could go up or down based on what they think is going on in the case, or the individual case, right?
Yes, child support and maintenance are in the sound discretion of the court.
But if there is no deviation, this is what would be ordered.
Correct.
And in this case,
Objection, Your Honor. I don't know that we could, that's a fair conclusion based upon the evidence. I mean,
That will be overruled. People are allowed to present that evidence, and it goes to motive as well as the reasons that the court allows the hearsay statements. So you may proceed.
thank you, Your Honor. And so we see down here, this is if, it says percent of overnights. If Becky gets 40% of the overnights and Tim gets 60%, that's what this is based on.
Correct.
And under those guidelines, there is, the defendant is not ordered to pay any child support.
Correct.
And maintenance is $1,379.42.
That's correct.
And in determining whether or not to order maintenance, one of the things that the court may consider is the disparity in income, correct?
Correct.
They also may consider in determining whether to order maintenance if financial assets are being hidden.
Yes.
At the time that Becky was killed on February 23rd, 2023, had you received any information from the defendant's attorney that the defendant had given up that CZ-75?
No.
Had you received any information from Becky that she had gotten that gun back from the defendant?
Never.
questions, Your Honor. Thank you.
Ms. Schnock, before you start, Mr. Timberwolke, I'm going to ask you to explain a few things because we use terms as attorneys that lay people may not be familiar with. So first of all, we've made reference to a GAL report. The GAL stands for guardian ad litem, is that correct?
That's correct, Your Honor.
And in this case, there is a guardian ad litem that was used, is that correct?
Yes.
What is the purpose of a guardian ad litem?
A guardian ad litem doesn't represent either parent. The guardian ad litem represents the children. The ultimate goal is for him to make a recommendation, in this case it was a he, to make a recommendation to the court as to what's in the best interest of the children. That would include parental decision-making and parenting time.
And Mr. Timberwolke, that guardian ad litem, at least in this case, is appointed by the court, is that right?
That's correct.
And is that an unusual procedure?
It is not unusual. In contested matters, it's often done, that procedure is done, and it benefits and assists the court in making its final decision.
Thank you, Mr. Timberwolke. Ms. Schnock, you may proceed.
Thank you. Mr. Timberwolke, am I correct that you would have gotten involved in this divorce sometime around November of 2021?
You are correct.
Okay. And during your involvement in this case, there was extensive discovery that was exchanged, correct?
Correct.
And along those lines of discovery disclosures would have been witnesses that would testify at trial, correct?
Correct.
And the witnesses that testify in any divorce trial are required to be disclosed if they are requested in discovery, correct?
That's correct.
And in this matter, that request was made of you and Becky to disclose all witnesses, correct?
That's correct.
And that was done, correct?
Yes.
And so it was no surprise that these people were going to be testifying in the divorce matter, correct?
Objections. Cause for speculation.
In this case, that'll be overruled. You may answer, Mr. Timberwolke.
It should have been no surprise, right?
Okay. Everybody knew it was coming.
Hopefully, yes.
Okay. Also, during the course of your representation of Ms. Bliefnick, you never personally filed for an order of protection naming Tim as the respondent, correct?
That's correct.
And even though there was that scheduling order entered with the court setting this matter for March, that was not the first setting of the final divorce, correct? It had been set for a final hearing at least twice prior to that. Is that fair?
I would have to review the docket on that. I'm not 100% sure.
Your Honor, I would request that Mr. Timberwolke be allowed to review the docketing statement.
If you reviewed the docking statement, would that refresh your memory, Mr. Timberwolke?
It could, yes, Your Honor.
Mr. Timberwolke, to save time, I have pulled up the document, the docketing statement and the minutes. It looks like there's an order entered 11/17/22, setting it for hearing, and 9/30/22.
Yes, Judge, I just saw the 9/30/22, so in answer to her question, I believe that it was scheduled for hearing. The first order setting it for hearing was on 9/30, and it was scheduled for December 29th.
Thank you, Mr. Timberwolke. Ms. Keck was asking you about pretrial memorandums. And in her questioning regarding pretrial memorandums, she referred to them and you agreed that they're essentially a proposal to the court, correct?
Correct.
It is a litigant's position on what they believe the assets are, what they are worth, and what they think they should be done with them, correct?
Correct.
Within the bounds of the law.
Correct.
Okay, and if you don't ask for something in a pretrial memorandum, it's hard to ask for it at the final hearing, correct?
True.
Okay. And so when you file these pretrial memorandums, you want to make sure that they are as accurate as possible, correct?
Hopefully, yes.
Yes, okay. And as part of Becky's pretrial memorandum, you ran child support and maintenance calculations in preparation for the hearing, correct?
Yes.
Okay. And the child support and maintenance calculations in divorce courts in Adams County, we rely upon financial affidavits, correct?
True, in
Okay.
part. There's
In
other
part.
things.
There's other things that go
Right.
into it, but the financial affidavits lay out the parties' prospective income, expenses, certain deductions and the like, correct?
Correct.
Okay, and as divorce attorneys, we don't have to agree with somebody's financial affidavit, correct?
That's why I answered the other question. You don't always rely on that because the financial affidavit gives a figure by a party to it, but the best thing would be, for example, a check stub.
Sure,
If you're-
absolutely,
Right.
absolutely. And in calculating maintenance and child support, did you use a computer program that's commonly used in divorce court to generate child support and maintenance calculations within the Illinois statutory guidelines?
I did.
And did you prepare that on or about December 15th, 2022?
It would have been part of the pretrial, yes, so.
Okay, Your Honor, may I approach?
You may.
Okay. And I'm not offering this as an exhibit, Mr. Mitchell, simply to refresh your recollection. With this.
Objection.
We still have to mark it.
Judge, she said she's offering it to refresh his recollection. He's never said he needs to have his recollection.
That will be, first of all, if you'll mark it, and then that will be sustained.
Do you recall what you would have included in Becky's income in preparation for trial?
I would have used the information that I had for her as a nurse.
Okay.
And I would have used the most current information I had because she had returned, I believe, to Blessing Hospital by that time.
Okay. Now I'm handing you what is marked as Defendant's Exhibit 2. And are these the calculations that you provided as part of your pretrial memorandum?
That's Exhibit Q, I remember.
Okay, and as part of the maintenance calculations, what is the maintenance, and to be fair, that was going to be your request, Becky's request of the divorce court at the final hearing, correct?
Correct. This would be based on 50/50, and this is what she believed to be the correct maintenance and child support based on their incomes.
Okay, so that was her best case scenario as far as child support and maintenance calculations were as far as your request was concerned.
Objection. That's not what he testified to.
That will be overruled. This is cross-examination.
Answer, Mr. Timberwolke.
I wouldn't,
Let me rephrase that question.
Yeah.
You wouldn't ask for something on behalf of a client if it wasn't in their best interest.
that's correct.
Okay, and as part of the calculations that you provided to the divorce court, the maintenance amount was $1,346, correct?
True.
And that was what you prepared in December of 2022 in preparation for trial in March, I think, correct?
Correct.
And then Ms. Keck subsequently asked you to provide calculations based upon a 60-40 split, correct?
That's correct.
And that was what was identified as, I think, People's Exhibit 72C, is that correct? 74.
That's correct.
Okay, so 74 was prepared for preparation for this trial, correct? It was not
That's
prepared for the
correct.
divorce trial, okay? And the calculations for maintenance in People's Exhibit 74 is the same amount that is in Defendant's Exhibit 2, correct? 1,300, and almost identical.
The maintenance was correct, but the child support was different.
Correct, and so what is the maintenance amount on that figure that you have in front of you?
$1,346.
Okay, so the document that you prepared for trial was a maintenance amount of $1,346, correct?
True.
And you would agree that $1,346 is less than $2,100, correct?
Correct.
Okay, and 1,346 is still less than 1,379, correct?
Correct.
And these numbers are assuming that a court or that you accept the gross income of both parties is true.
That's correct.
Okay. And in People's Exhibit 74 that was presented to the court, that does not include the amount of maintenance that she was receiving from Mr. Bliefnick, correct?
You mean the existing order while the case was going on?
I'm talking about Exhibit 74 that was prepared in preparation of today's trial, and if the people want to hand that up or. And so People's Exhibit 74 does not include any amount of maintenance that she was receiving from Tim, correct?
You mean going into the trial?
I'm talking about what that document has right there in front of you. That includes her base income, correct?
Yes. Yeah, you mean her base income of $5,452 a month as a nurse?
Yes. And that's what she was claiming her base income was, correct?
True.
Okay. And that document that you have in front of you does not include the maintenance that she was receiving from Tim under the temporary order.
No, this would be the projected. The temporary order was different.
No, I understand that, but the line items on Exhibit 74 do not account for any maintenance being paid. Her income does not include the maintenance that she was receiving.
Correct.
Okay, thank you.
Right.
Thank
Right.
you. I can take that back. And so if that calculation had included the maintenance, then that could affect the calculations as well.
I've never included the maintenance as part of the income. The party's income from their employment in this case, for both of them, would be used to determine maintenance. You wouldn't also add on the maintenance.
Correct.
That's how you arrive at the maintenance.
But you would agree that's not included in that form?
I would agree it's not included in the form, right?
And in this matter, there was a dispute as to what Becky's income was, correct?
At one point, there was a major dispute, but by the time we went to trial, she had now returned to Blessing, and her income had stabilized because there was a period of time where she left and went to Kirksville, and she was a contract worker, which means she made a lot more money, and she was getting expenses for living expenses while she lived there and stayed there overnights while she worked.
And also in the preparation of your pretrial memorandum, you did not include any cash that Ted Johnson or anybody else for that matter was holding for her, did you?
I did not.
Okay, did you even know about $13,000 in cash being held on her behalf by somebody else?
I did not.
During your representation of Becky, did you ever file any petitions to show cause with respect to non-payment of maintenance?
No, there was something earlier, but I was not in the case at that time.
Okay. And you did not address any maintenance or child support arrearages in your pretrial memorandum, correct?
No,
Okay. As far as divorce procedure is concerned, it's not uncommon to try to settle cases before trial, correct?
it's not uncommon, that's correct.
Okay. And sometimes efforts work and sometimes they don't. Is that fair?
True.
Okay. And in reference to the settlement proposal that Tim sent, he was not unwilling to pay maintenance, correct?
Objection,
What's the objection?
speculation.
It says it right.
Rephrase the question, please, Ms. Schnock.
In the letter that Tim sent to Becky, he offered to pay maintenance monthly, correct?
He did.
And he offered to pay that for a period equal to 1/2 of the duration of the marriage, correct?
He did.
Okay. And the marriage was approximately 11.2 years, a little over 11 years.
He arrived at 70 months. I believe that's the way he did it.
Okay. And he was also, he was willing to continue doing that, and he was also willing to continue to pay for things like St. Peter's tuition, correct?
Yeah, but he was willing to pay maintenance, but he only wanted to pay $750.
Sure, and that could have been something, the divorce court could have accepted your number, sure, she could have accepted anybody's figures or could have done anything different that she wanted. As you said, that's in the purview of the court, correct?
That's true. The court would make the final decision.
And as part of this letter, it was requested that proof be provided that a gun safe was purchased by Becky, correct?
Yes,
Okay. And you stated with Ms. Keck, the only thing that you did after you received this is just say, no, we don't have a deal, correct?
that's correct.
And so there was no proof sent that there was a gun safe purchased by Becky, at least you did not do that, is that fair?
No, it was a simple no. It was rejected due to the many terms and proposals he was making.
Okay. And as far as the guardian ad litem report that you referred to, the recommendation was part of the second supplemental report of Mr. Zimmerman, correct?
The 50/50?
Yes.
Yes,
And that was made by Mr. Zimmerman on February 20th, 2023, correct?
correct.
Okay. And he made several observations of the parties and their issues as part of that report, correct?
Yes,
And the biggest issue at that point was their ability or inability to communicate effectively, correct?
yes, he showed concerns for that issue.
No other questions, Judge?
Ms. Keck?
Mr. Timberwolke, after Becky Bliefnick was killed, how much maintenance was the defendant gonna have to pay?
Objection.
That will be overruled.
0.
No other questions, Your Honor.
You may step down.
Thank you, Your Honor.
Could you hand up
Sure.
exhibits? Mr. Jones or Ms. Keck?
People would call Rick Zimmerman to the stand.
Ladies and gentlemen, while we're waiting for Mr. Zimmerman, you are free to stand up and stretch if you wish to.
We don't have to, just stretching. You can, yeah. And honestly, I need more of this than I do.
stretching, Mr. Zimmerman.
That's fine.
Well, he's coming up next.
All right, please be seated.
You do solemnly swear that the testimony may give in the cause and opinion before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come around here. Have a seat in the chair, scoot up to the table to where you're comfortable. And then bend the microphone so it's in front of you, and please speak towards the microphone. And Mr. Jones, you may inquire.
Can you tell me your name, please?
Rick Zimmerman.
What do you do for a living?
I'm an attorney
Where do you work at, Mr. Zimmerman?
in Mount Sterling, Illinois.
What kind of law do you practice? What's your focus?
General practice, primarily criminal defense and family law.
In family law, is there a particular role that you sometimes fulfill at the request of a court?
Yes,
And what's that role called?
I serve as what's called a guardian ad litem.
Sometimes we'll hear that called the GAL, is that right?
Yes,
Guardian ad litem is how attorneys get paid $250 an hour to explain stuff.
well, the rate varies, yes, but
Can you tell me what a guardian ad litem is?
simply the role of a guardian ad litem is to represent the best interests of the children involved in the case, whether it be a divorce, a family, or other type of case.
So if there's a divorce or some type of family case, the court will appoint an attorney who's not representing the mother, not representing the father, not representing the husband, not representing the wife, but who's there to represent the children that are involved.
The best interest of the children, yes.
The best interest of the children.
Yes.
How long have you done that?
As far as doing guardian ad litem work, I think 2, maybe 3 years.
And I know we've covered this, but you're appointed by the court, you're not hired by the parties. Is that also correct?
That's correct.
So you're not there to make a decision that favors one side or the other. You're there to look for the best interest of the children.
Yes.
How do you do that as a guardian ad litem? How do you decide what you're going to tell the court and the parties that, in your opinion, is in the best interest of the children?
I'll conduct an investigation. During that investigation, I'll talk to both parents. I'll talk to the children. I'll talk to third parties if there are third parties who have information that's relevant. And often I'll review documents submitted by the parties as well.
In reviewing those documents, does that include sometimes text messages from the Our Family Wizard app?
Yes, sometimes.
What is the Our Family Wizard app?
It's primarily a communication tool and used in divorced families or separated families. It allows the parties to communicate and those communications to be monitored and prevents either party from tampering with the communications.
Is it an app on your phone?
It can be, yes.
And is it a messaging app? So if you're going to, let's say, for example, a husband and a wife are ordered in the process of divorce to use the Our Family Wizard app. If they're going to message each other, they are ordered to type those messages into the Our Family Wizard app. Is that right?
Yes.
And then the app will send the message to the other party?
Yes.
The application records that message?
Yes.
It sends it to the other party. If the other party chooses to respond, they're required to respond through that application as well.
Yes.
And you did tell us this, but that app records those conversations, stores those conversations so that they can be reviewed at a later time.
Yes.
Are you one of the people that can review those messages?
I have in the past, yes.
In this case in particular, were you appointed to be the GAL for the 3 Bliefnick children, Grayson, Arlen, and Deacon?
I was.
When were you appointed to do that, if you recall?
I believe it was in 2021, sometime in the summer, I'm wanting to say.
When you are the guardian ad litem, you said you performed an investigation, is that right?
Yes,
Did you do an investigation in this case?
I did.
You told us in general you'll talk to both the mother and father. Did you do that in this case?
I did.
You told us that in general you would talk to the children. Did you talk to the 3 children in this case?
Yes.
Specifically with regard to the defendant and Rebecca, his wife, I guess I should ask you this. Do you see the person in court that you spoke with that you know as Tim Bliefnick?
Yes.
Can you point him out and describe him?
He's sitting at the end of the council table, wearing a sweatshirt.
We'd ask that the record reflect he's identified as the defendant.
The record will reflect that the witness has identified the defendant.
You spoke with the defendant in your investigation?
Yes.
When you speak with these parties, what kinds of questions are you asking them? What are you talking about?
Typically, I'm asking them about their background, the history of the relationship between the parents, the typical relationship they have with their children, any incidents that may have occurred that reflect what has led to the breakdown of the relationship, and what they would like to see happen as a result of the court case.
And when you say what they would like to see happen as a result of the court case, are you talking about parenting time, custody split, things like that?
That's correct.
Did you speak with the defendant about those issues, parenting time, custody split?
Yeah, I have.
And when you spoke with the defendant, what was his position?
His request was always that he have majority parenting time.
At that point, when you were the guardian ad litem, were you aware of what the current, I'll use split, or the current divide was?
I was. It changed at several points during the course of the divorce, but I was made aware of it, yes.
And at that point, what was the custody division?
The most recent was, it was 50-50, or equal division.
Did you also speak with Becky Bliefnick about the custody division?
I did.
And was her position that it should be 50-50?
Yes.
Did she also share with you a concern that she had, not about the custody split, but about who could be around the children?
She did.
And what was the nature of that concern?
She was concerned about Mr. Bliefnick's father being around the boys.
Did she want the three boys to be around the defendant's father?
Not in an unsupervised capacity.
Did you review the text messages on the Our Family Wizard app between the defendant and Ms. Bliefnick?
I did not review the entirety of their text messages. What I did was just kind of took a random selection to get an idea of the communication between the parties.
And you also spoke with Mr. Bliefnick, the defendant, and Rebecca Bliefnick?
Yes.
What was your sense of the divorce, how the divorce was going, based on the review of the text messages and the conversations that you had?
It was a very contentious divorce. It was hard for the parties to find any kind of agreement, it seemed like.
And I want to be fair, was there animosity on both sides? When I say that, was there animosity from Rebecca towards the defendant, and was there animosity from the defendant towards Rebecca?
Absolutely, both ways.
It went both ways?
Yes.
In reviewing the messages, were there, I won't say inappropriate, but were there messages that dealt with that animosity that you reviewed from both sides?
Yes, it was clear they were arguing in the messages.
In the course of the investigation, did you speak with me about those conversations? The animosity?
Did I speak with you regarding it?
In preparation for trial?
Oh, yes.
And talking about that, did you tell us that they were basically fighting about everything?
Yes.
Fair to say?
Yes.
They would make mountains out of not just molehills, but hills.
Yes.
I also want to be fair in reviewing the messages that you reviewed. Did you ever observe or see any acts of domestic battery?
No.
Thank you. That's all the questions I have.
Ms. Schnock.
Thank you. Mr. Zimmerman, as part of your involvement in this case, you filed a second supplement to report of guardian ad litem, correct?
That's correct.
And you filed that on or about February 20th of 2023, correct?
Yes.
And would you have met with both Tim and Becky prior to preparing this report?
Yes.
Okay, do you remember when you last met with Tim?
Off the top of my head, I don't. I do have my notes if I need to refer to those.
If that would refresh your recollection, I would ask that you be allowed to do so.
We have no objection.
All right, you may do so.
The note I had from my last meeting with Mr. Bliefnick was on February 17th of 2023.
And how long did that meeting last?
I don't know off the top of my head. I don't believe it was a very long meeting.
Okay, and when was your last meeting with Ms. Bliefnick?
It would have been on February 16th of 2023.
All right, and did either of those meetings involve the kids?
I don't believe so, but I did meet with the children for the last time also on the 16th, but I think they came in, I seem to recall Ms. Bliefnick may have came in and then come back with the children later.
Okay, that's fair. And this was the final report that you filed prior to the scheduled hearing date in March, correct?
Yes,
And before you filed this, it had been quite some time since a report had been made to the court, correct?
that's correct.
And so the court was requesting an update on things had been going since the last report was filed, is that fair?
Yes,
And the current parenting, were you made aware of the current parenting time schedule that they were operating under at that time?
yes,
And was that schedule agreed upon by Tim and Becky?
yes,
And that was that Tim had the kids on Mondays and Tuesdays, Becky had them on Wednesday, Thursday, and they were alternating who had the weekend, correct?
yes,
And both of the parties reported to you that they were able to come to that agreement without court involvement, correct?
Yes.
And so for two people that were making mountains out of anthills, they were able to come to an agreement on a schedule without the need of their attorneys or a judge, at least at this point, correct?
that's correct.
Okay, and as divorce attorneys, that is something that you like to see when you have two people that are making mountains out of anthills come together and agree on something without the need of two attorneys, a guardian ad litem, and a judge.
Absolutely.
Okay, and you mentioned at the back end of your report that neither party seemed inclined to want to continue to agree to that schedule.
That's correct.
Were they both wanting to make changes to that?
Mr. Bliefnick expressed that he did not like the schedule. Ms. Bliefnick was not happy with it, but seemed more willing to go along with it.
So neither one of them liked it, but they agreed to it nonetheless?
That's correct.
And was that in large part because it was working for the boys?
I believe so.
And when you get a parenting time schedule together, you're more, as a guardian ad litem, more concerned about how it works for the kids as opposed to how convenient it is for mom or dad. Is that fair?
Absolutely.
Okay. As part of your report that you made on February 20th, you made the observation that the biggest issue at that time was the parties' inability to communicate effectively to one another. Is that fair?
Yes,
And there were certain accusations made on both sides regarding communication, correct?
that's correct.
As far as those allegations are concerned, were they fairly innocuous?
Yes, I mean, the parties were not communicating well, but, I mean, it wasn't violent or anything like that.
Sure. And after you met with both Tim and Becky on these last respective occasions, you had no red flags going off in your mind that things were going poorly. Is that fair?
Yes,
Okay. And there was nothing in your mind that the children were unsafe with either parent, correct?
no,
There were no safety issues with respect to the kids, correct?
not that I was aware of.
And there was nothing in your report that alluded to any red flags with respect to domestic violence, correct?
Correct.
And as part of your report, you also recommended joint decision-making, correct?
Yes,
And a joint decision-making scenario is when you expect mom and dad to come together to make decisions for kids, such as where, what sports team they're going to play for, what daycare they're going to go to, what doctor they're going to go to, correct?
yes,
And joint decision-making tends to require some amount of cooperation on the part of both parents, correct?
yes,
And despite the fact that earlier in the divorce, they were making mountains out of anthills, you still believe that they could come together to make decisions for the best interest of the kids, correct?
yes,
And that's what you hope for, correct?
yes,
Your Honor, may I approach?
You may.
Mr. Zimmerman, I'm handing out what is marked as Defendant's Exhibit 3. Is that your second supplemental report?
Yes,
And is that your signature on the back page?
yes.
Your Honor, I would ask that Defendant's Exhibit 3 be admitted.
Any objection?
It's part of 72, so it doesn't need to be because it's already part of.
I would just
70.
ask, I guess it could be a joint exhibit.
That's fine, I don't have a problem with
Okay.
that.
What the court's going to do, because that is part of Exhibit 72, which has been admitted, then I'm going to have you change the markings on that, and we will call it 72D.
Peoples.
That's fine.
Okay.
So that it can be found and made a record of, and it can be considered part of a joint exhibit.
Your Honor, may I approach?
You may.
There's the correct exhibit, Robert, that was.
All right.
I have no objection to that being offered and introduced, Your Honor.
Okay. And then Ms. Keck? Mr.
I'm done.
Jones?
Mr. Zimmerman, I want to talk about that last conversation you had with Tim Bliefnick on February 17, 2023. And in regards to the current parenting plan, was the defendant wanted more than 50-50, is that right?
Yes,
So he was not happy with the 50-50 split.
that's correct.
The victim, Rebecca Bliefnick, didn't like the 50-50 split, but was willing to go along with it.
Reluctantly so, yes.
After Rebecca Bliefnick was found murdered, did she have any parental rights at that point?
I would assume no.
That's all the questions I have.
Ms. Stock, want another shot?
Nothing. for Mr.
All right,
Zimmerman.
you may step down.
Thank you, Your Honor.
Do you need Kick that back. All right, ladies and gentlemen of the jury, we have an issue as far as other witnesses go. We are going to break for lunch now. We've got some work to do before we have that next witness. So you are free to go to lunch. You are to return back to the jury room by 10 till 1, because we will plan on starting right at 1 o'clock again. So you are free to go for lunch.
All right.
All right, and then, council, we will go ahead and break for lunch. We We'll need to be back here by 1:45. We will hear that evidentiary hearing. So I will need the defendant here by 1:45.
Judge, can we do that before we break for lunch? 'Cause that
You
will-
want to do that now?
Yeah, we can do it. We're ready.
Okay.
Essentially, and then we can,
Okay.
that'll affect how we go
All
forward
right.
with the witness.
All right, then let's go back in chambers and take care of that. We will be in chambers for the next few minutes. All right, please.
Go back on the record.